Friends, we are going to start now. Today is the 263rd Friday group meeting. The topic is maintenance for adult dependent children in India, a remarkable step forward in section 144 in BNSS, new criminal laws. Today's speaker is Mr. Pranab Kumar Mullick, a good friend, one of the prominent advocate on record, is a gold medalist also LLB and BCom honors. So he is going to deliver on this. So Mr. Naveen will say a few words about our Pranab Mullick.
Good afternoon, everyone. Sir, thank you for the privilege. Welcome, sir. May I now read the CV? Mr. Pranab Mullick is practicing as an advocate of Supreme Court since 1990 and as an advocate of record since 1996. He is an NTSC scholar, CBSE Commerce stream topper in class 12 and gold medalist in both BCom honors and LLB from University of Delhi. He has been an amicus in several matters in the Supreme Court of India, including cases related to the erstwhile Mental Health Act and DK Basu case, a very famous case. He has written several legal articles, including one on the topic on hand before the change introduction by section 488 of BNSS. He has also literary interest and has published book on political mythological fiction, Kanha to Krishna. Thank you, sir.
Good afternoon and namaskar to you all. I'm really honored to be here this afternoon, and thank you to Friday Group and to its indefatigable founder, my good friend G.Seshagiri Rao. And today being the 263rd meeting, it is really a testament to his perseverance and dedication, selfless dedication. So today the topic, it relates to maintenance provision for children who have crossed the age of 18 years but then remain dependent on their parents for educational expenses and for their maintenance. A big change has been brought about in this respect under section 144 BNSS, and we are going to discuss it today. We are all aware of the provisions of section 125 CRPC relating to children. And now this 125(1)(b) of CRPC, erstwhile, so it provided that if any person having sufficient means neglects or refuses to maintain his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, then the magistrate may provide for monthly allowance. Now section 144 BNSS incorporates the same section 125 CRPC with one significant change. The word minor, which qualified the word child, has been removed. Now this change has not come about easily, nor has it been widely publicized. And in today's discussion, we shall trace the history of this change, how it came about, the significance of the change, the repercussions, the law abroad, as well as the issues which will arise by reason of this change. And this topic is very dear to me because in a very small way I had a role to play in this, which I shall explain subsequently. Now let us first see what law was prevalent earlier. Before section 125 CRPC, there was CRPC of 1898 and section 488(1) was a contemporaneous provision. I will just read out that section. If any person having sufficient means neglects or refuses to maintain his wife or his legitimate or illegitimate child unable to maintain itself. So that section 488(1) of the erstwhile CRPC 1898, it referred only to child, not to minor child. So in that way, it is very similar to the present BNSS provision. Now, when the courts at that time interpreted this provision, this section 488(1) of the erstwhile CRPC, they took two divergent views. One set of judgments took the view that child means only the offspring. Since minor is not specified, so age restriction will not be there. There is a judgment of the Madras High Court, this Parappat Chinna versus Sakkundi Menon, 1919-37 Madras Law Journal 361. It was a division bench judgment. So Justice Napier, he observed, I am therefore strongly inclined to think that the words unable to maintain itself cannot be confined as suggested to the tender age of the child, but must also have reference to its financial dependency. That is, the tender age of the child is not an issue. You have to see whether the child is financially dependent or not. This was further expounded in Kent versus Kent. This is 1926, AIR 1926, Madras, page 59. So there the court observed that even a grown-up child, if unable to maintain itself, is entitled to get maintenance from the father if he has the means. However, at the same time, there was another parallel line of cases which held that no, the child must mean a minor child. So this was the same Madras High Court in Krishnaswamy Iyer versus Chandravadan. This is 1913, volume 25, Madras Law Journal, page 349. And there was Subbamma versus Venkata Reddy, AIR 1950, Madras 394. Plus there were also judgments of Calcutta High Court, Lahore High Court, Bombay High Court. All of these held that no, there must be an age restriction. A child must be a minor child who will be entitled to maintenance. Now both these views were considered by the Madras High Court in a judgment in Amrithammal versus K. Marimathu, 1966, through Madras Law Journal 506. And after a detailed discussion of both these viewpoints, the court held that no, the child must be a minor child in order to be entitled to claim maintenance. So this position remained. Now, the laws that we have regarding maintenance to children, one is section 125 CRPC, the second is section 20 of Hindu Adoption and Maintenance Act, third is section 26 of Hindu Marriage Act, and the fourth is in Muslim law. Now all these provisions, they stated that the child has to be a minor child under the age of 18 years in order to be entitled to claim maintenance. There were two exceptions to this rule. One was where the child has attained majority but by reason of any physical or mental abnormality or injury is unable to maintain itself. This is in section 125 CRPC. The other is an unmarried daughter who is unable to maintain herself out of her own earnings or other property. This is contained in section 20 subclause 3 of HAMA, Hindu Adoption and Maintenance Act. Now if we come to see the practical situation in India when a child completes 18 years of age, he has just about completed class 12. So at that stage he is not earning anything. So whether for his further education, whether for his maintenance, he will be fully dependent on the parents. Now this is totally different from the situation prevalent abroad. In Europe, in USA, there the children, they start working in stores, they doing manual labor. So their dignity of labor is respected. That is not there in India. In view of the societal conditions, lack of employment opportunities, so all that the children are unable to have their independent income. So they are forced to remain dependent on the parents. Now consider a divorce case, a matrimonial case. In a divorce case, the court grants custody of the child to one parent or the other. Now the child has his needs. So whichever parent gets the custody, the custodial parent, he has to bear the entire burden of expenses, whether for education, whether for maintenance, everything. But law says that no, after the age of 18, he is not entitled to claim any maintenance. So what happens is, the entire burden of expenses falls on the custodial parent, while the non-custodial parent goes scot-free. And custodial parents in most of the cases we have seen is the mother. So that custodial parent suffers, is burdened by these expenses. Now, the law says that no, after 18 years you are not entitled, and the Supreme Court upheld this in respect of section 125 CRPC. In the case of Amrendra Kumar Paul versus Maya Paul, this is 2009 volume 8 SCC 359, the Supreme Court categorically held that section 125 CRPC will cease to operate once the child attains the age of majority. There was another case, recent case, Abhilasha versus Prakash and others, 2021, 13 Supreme Court cases, 99. Again, there the girl had attained the age of majority. The Supreme Court held that no, she will not be entitled to maintenance under section 125(3). But since the girl was unmarried, Supreme Court said that you explore your remedy under section 20 clause 3 of HAMA. Now, although by statute as well as by judicial interpretation, maintenance could not be given to a child, maintenance could not be claimed by a child who has attained the age of 18 years, yet the Supreme Court itself in its 142 jurisdiction, as well as other courts, high courts and district courts, have molded the relief to somehow provide reliefs to even children who have crossed the age of 18. I will come to those line of cases a bit later, but first let us see what is the position, what is the law prevalent abroad. Now, if we see the statutory law which is prevalent abroad, now in Europe, let us take Europe first. The Hague Convention of 2007, Hague Convention on the International Recovery of Child Support and Other Forms of Family Maintenance, 2007. Now this convention, India is not a signatory to this convention. Now many of the signatory states who have signed the convention, now let us see what is the age till which support is extended to the children in those countries. European Union, it is 21 years of age. Albania 21, but then 25 for high school or university students. Bosnia Herzegovina 21, Norway 21, but 25 can be recognized by the courts. Turkey 21, but then 25 if education continues. Ukraine 18, but 23 for students. UK, it is 21. Now, some EU countries have even higher protection, additional protections. In France, for example, Article 371(2) of French Civil Code, it expressly provides that liability to provide financial support continues till the child is in a stable position even after the child has attained 18 years of age. Very interesting. Till the child is in a stable position. And the parents' financial support includes university education. Now, like in many countries, it is that that post-graduation is not the liability of the parents. But France, it says university education. In Spain, the child after attaining adulthood, he is entitled to directly claim for maintenance from parents during university or till it obtains financial support for itself. So it goes on. In Lithuania, Article 3.194 of the Civil Code of the Republic of Lithuania, that was amended in 2004, and that provides that the court can adjudge if the maintenance, if the child is in need of support, he is a full-time student of institutions of secondary, vocational or higher education, and he is not older than 24 years of age. Greece provides 24 years of age if in full-time education. Then Ireland is till 23 years of age if involved in full-time education. Australia is very important. Section 66L1 of Family Law Act 1975 states a court must not make a child maintenance order in relation to a child who is 18 or over unless the court is satisfied that the provision of the maintenance is necessary. Now this exception, that unless the court is satisfied, that has been very liberally interpreted by courts all over Australia. So it is left to the discretion of the courts, and the courts there, they consider diverse factors. Like for example, the parents who are expected to pay must have the financial capacity to pay. Secondly, it is necessary for the child to complete education. Now what is the meaning of the word necessary? There is a judgment, Everett versus Everett, 2014 judgment. So the court held that necessary does not mean absolutely essential, but rather that the maintenance is needed by the child and it is reasonable to require the parent to contribute having regard to the parent's financial circumstances. There was another case, Re-AM Adult Child Maintenance 2006 case. So there the court held that necessary means something more than morally or socially desirable, but less than absolutely necessary. Then the child's ability to complete the course is also looked into. So his past performances, that whether he will actually be able to complete the course or he is just, in order to claim maintenance, he has just enrolled into the course. So that also is a factor which is taken into account. Then the amount of maintenance in Australia, that will cover not only the course fees but also boarding and lodging. This is different from that prevalent in USA. I will just come to that. Now we come to Canada. In Canada, there is Divorce Act of 1985. It says a child of the marriage who is unable by reason of illness, disability or other cause to withdraw from the parent's charge or to obtain the necessities of life will be entitled to maintenance after the age of 18 years. Now courts again have said that other causes will include university education, so they are liberally giving them. USA, very important, very interesting also. There the family law is in domain of the states, so every state has its own law and it differs. But then one thing is generally that unemployment or underemployment does not merit grant of maintenance, because there they have unemployment insurance, they have social security. So for that, maintenance is not granted. The parents are not required to contribute to the maintenance of the child on ground of unemployment or underemployment. So there in all the states, the position is that the parents contribute a part towards the university education, towards college education, university education. Various states like Colorado, Iowa, they permit university fees support, post-secondary education subsidy if good cause is shown. Then, very interestingly, the Washington Supreme Court, it permits educational support on a constitutional ground. It says that there is a duty to pay post-majority child's college education in view of the state's strong legitimate interest in ensuring education. So that is why, since the state has an interest in ensuring that everybody is educated, so therefore parents should contribute towards the educational support of their children. Now comes to Poland. Poland is a class apart. It is totally different from rest of the West, very similar to that of India. In Poland, the courts have ordered child support for unemployed adult children not able to provide for themselves as a statutory parental obligation. In Poland, there is an act. It is the Family and Guardianship Code of 25th February 1964. There it is called KRO. So under Article 133 subclause 1 of this KRO, parents are obliged to provide maintenance to a child who cannot provide for himself or herself unless the child's income from property is sufficient to cover his or her maintenance and upbringing. So now, after having seen the position abroad, now we come to, in India, what the courts did to get over the bar enshrined in section 125 and the other maintenance laws. First we come to the Supreme Court decisions. In Kirti Malhotra versus N.K. Malhotra, 1995 Supplement Volume 3 Supreme Court Cases, page 522, the Supreme Court directed the respondent father to pay maintenance of rupees 3,000 per month to the son who was 18 years of age till he attained 27 years of age. Very interesting judgment. From 18 years, the court said that you have to give maintenance till the child attains 27 years of age, and no law was discussed. Evidently, this was done in exercise of Article 142 powers. There was another Supreme Court judgment in Rita Datta versus Shubhendu Datta, 2005 6 SCC 619. So there the Supreme Court again awarded monthly maintenance to the two adult sons of the petitioner in order to enable them to complete their education. Again, the law was not discussed. This was a directive under Article 142. In Chandrasekhar versus Swapnil and others, Criminal Appeal 265-266 of 2021. So there the Supreme Court upheld an arrangement that provided that maintenance would be provided to the child till he completed his first degree course after high school in order to ensure that he becomes a self-supporting individual. Now, Supreme Court judgments we can say were passed under jurisdiction of Article 142. But what do we say to the judgments passed by the High Courts, granting relief, granting maintenance to children above 18 years of age? The Uttaranchal High Court, in the case of Mohan Singh Mauri versus Srimati Haripriya Mauri, this is 2017 SCC Online Uttarakhand 117. It considered the situation where the adult unemployed son was dependent upon the mother. Now the court, what it did was it substantially enhanced the maintenance paid to the mother to cover for maintenance expenses of the adult child. It does not give directly to the adult child, it is increasing the support of the mother. Now see the observation that was made. Though an adult child cannot claim maintenance from his parents as a matter of right, but in the Indian culture, we cannot forget the fact that the parents have to maintain their adult child till he gets suitable employment, and it is a social duty cast upon the parents to maintain the adult child. This Indian culture and custom cannot be compared with the European culture and custom. So the court takes note of the difference between the Indian culture and the Western culture. Now, you see the section 125 CRPC and now this 144 BNSS, these have been held by the courts as provisions basically to avoid starvation and vagrancy. Do educational expenses fit in? Educational expenses are not for avoiding starvation or vagrancy. But then the courts have held that since now education is a fundamental right, even otherwise it is a basic need. So although it is not associated with starvation or vagrancy, yet educational expenses can be claimed under section 125 CRPC or the new section 144 BNSS. But then an adult child, he cannot continuously claim indefinitely. He cannot say that I will continue to study and therefore I am entitled to maintenance. It must stop at a certain stage. So it is held by the courts that parents are not liable to provide for educational expenses at the postgraduate stage onwards. So till graduation it is okay, but not post-graduation. Now, one more interesting aspect, marriage. What if the child is married? Now, both section 125 CRPC as well as 144 BNSS, it says that his legitimate or illegitimate child, whether married or not. So it includes a married adult child also. But then it does not say whether the maintenance will be for maintenance of the child or also for the spouse of the child. So that is one aspect which has to be decided by the courts. A scenario might arise. You see, having a statute is fine, but then what about compliance? We have seen in section 125, all maintenance cases we have seen, the husbands, they have been directed to pay maintenance, they are not paying. In India, the compliance level is very low. Even in US, the compliance is only 42.16%. And it has been found that only 27% there is, in 27% cases there is no compliance. And only in 42.16% there is full compliance. The remaining, it is part compliance. In India, we do not have proper data regarding the level of compliance of maintenance. So unless you are able to get the provision complied with, it has no meaning whatsoever. Then the question of delay. We have seen, we are all aware, we are all in this profession, we are all aware of laws delays. In fact, just the other day, this Monday, I was arguing a case where the litigation had started in 1974. So this was 51st year of litigation. So I mean, if this continues, like an adult child, he will reach middle age before the courts even get to consider as to whether he is entitled to maintenance, and then compliance. So one more aspect that will arise more in future times is regarding sharing of the burden. The parents, it is said that the parents will be liable to pay. Now, which parent pays how much? Now, you see, this section 144, earlier 125 CRPC, and now this 144 BNSS, these are basically modeled on the male breadwinner concept. Most of the laws, even abroad, these are modeled on the male breadwinner concept. But then the situation is rapidly changing. The percentage of women in the workforce is rapidly increasing, and women are taking on corporate jobs and full-time jobs. Earlier, I mean, in earlier schools used to be from 8 a.m. to 2 p.m. Then the mother is free to take care of the child. It is no longer that situation. Even in schools now, it goes on to 6, 7, 8, and then they take home the work. So when this is the situation, when both parents, they do not have the time, then, and both are earning, both do not have the time, so then the proportion has to be worked out as to who pays how much cost, who devotes how much time. This time cost proportion, this is an issue which is going to arise in future, increasingly which it is going to arise in future. So this is basically how we have traversed through the topic, that the maintenance to adult children, earlier it was not allowed, the courts somehow they managed to give some relief somewhere, now it is legitimized, now it can be given, but then how much, and new issues that are going to arise, so we have covered in this topic. So it has been, so any questions, any?
Yes, please. Yes. Thank you very much, Mali. You covered very extensively this topic, very demanding in fact. It's a burning issues also, various countries and etc. So I request Rahul Sharma will give vote of thanks, please.
Seshu sir has given me the privilege of expressing the vote of thanks, and I am deeply grateful for this honor. Sir, on behalf of Friday Group, I would like to thank Mr. Pranab Kumar Mullick sir for sharing his thought, experiences and knowledge about the maintenance for adult dependent children in India, a remarkable step forward in section 144 BNSS. This section, which reiterates the provisions of section 125 CRPC, with one significant difference: the word minor qualifying the word child has been removed. So you talked about the Hague Convention 1996 on parental responsibility and the protection of children, and the laws related to the child protection in France and other European countries, which are based on, like in France, the criteria is the university education for children, and in some other European countries, like the stability position of the child. So we hope we'll be fortunate enough to be favored by another lecture soon. And on behalf of the Friday Group, I thank everyone for your attendance and participation in making it a resounding success.
Thank you, Rahul. Thank you very much. Take your seat.